Good morning and welcome to a very special edition of Black Press USA's Fire. This morning, it's all about Bill Cosby. 2 years ago, a little bit more than 2 years ago, Bill Cosby was sentenced to 3 to 10 years in prison for aggravated indecent assault against Andrea Constant, a former lover of Bill Cosby, a former love interest, I should say, and Temple University employee. The Black Press in 2017 traveled to Pennsylvania to Pittsburgh to jury selection in the first trial of Bill Cosby in this matter. We went there expecting a smoking gun. We went there expecting that there would be a mountain of evidence to show that Bill Cosby had committed the crime for which he was charged. After 2 trials and constant coverage by the Black Press, we found so much to be horrified by. Not because Bill Cosby is a celebrity, not because Bill Cosby is an entertainer and is famous, but because Bill Cosby, a Black man, was pretty much, in the words of his spokesperson, Andrew Wyatt, lynched. It was a modern day lynching, Andrew has said. Well, we witnessed it, and there was nothing there to suggest that Bill Cosby, at his age and with his history, should be spending as many as 10 years in prison for pretty much an incident in which a young lady said he fondled her. This was not a case where a lot of people believe, they say he raped somebody or he's a rapist. This wasn't an intercourse thing. Both parties, Bill Cosby and Andrea Constant, admitted that there was never any intercourse. They also both admitted that they had a relationship. A lot of these facts you have not heard in mainstream media. You won't hear in mainstream media. They were there, though, and they heard about it. They heard what we heard in that courtroom. They also saw a district attorney in concert with a judge decide that Bill Cosby was a sexually violent predator without any evidence. Today, we're going to hear from Andrew, but we're also going to go take you to the courthouse where the Pennsylvania Supreme Court has decided that they want to hear what really happened in 2018 that led to the conviction of Bill Cosby. Andrew, I know you have a lot on your mind. I know that this is a big day for the Cosby family. I know you've been talking to Mr. Cosby. In fact, you probably talked to Mr. Cosby more than Mrs. Cosby talks to him. So, Andrew, as this day dawns, what's going through your mind?
Well, first, Stacey, good morning. Good morning to the NAPA audience. Thank you and your CEO, Dr. Ben Chavez, your producer, Norman Rich, for giving me the opportunity to be here on this day. As I have stated in a number of interviews, this is the World Series of Bill Cosby's life. This is the NBA Finals of Bill Cosby's life. This is the Super Bowl of Bill Cosby's life. Not only life, but the restoration of his legacy. It has been a well-anticipated, day and year. 2020 has been an eventful year. It has been an eventful year where we saw in current events, senseless deaths of Black men and women, at the hand of a few bad officers, not all. We have witnessed the unjust incarceration of Bill Cosby. We have witnessed disarray in our political system, our American political system, and we're experiencing a pandemic. And, people say, why do you mention all of those things? What do they have in common? Black people. They all have Black people in common. And we have seen, Mr. Cosby as a Black man, a Black cultural icon, an American citizen, an American treasure. We have seen charges and an unjust conviction waged against him. No evidence, no proof, just because somebody said it happened. And also we have witnessed this same individual, Andrea Constant. That's who he was on trial with. But the trial turned into not just a trial with Andrea Constant, but 5 other people.
Well, let me stop you there for a second, Andrew, because that's one of the points that the Supreme Court said, time out. We need to examine this. Why did Judge Stephen O'Neill, in the first trial, he allowed one other woman testify that about decades old, unproven allegations. But the Supreme Court this past summer said, wait a minute, 5? Why 5? We want to know. That was one issue, right? And the other issue they decided to take up, and in reality, folks, they could have picked a dozen or more issues, because this case, if you were there, and that's the point, not relying on what you heard coming out of that courtroom from mainstream media. In fact, there was a couple of mainstream associates, put it that way, who confided that the trial was a farce. These people, they won't go on record, and we're gonna respect their decision not to. But the second thing was this, and this is so just as important as the 404B witnesses, right? This is extremely important in criminal justice, especially for Black people. The prosecutor in the original case, Bruce Castor, when Andrea Constant decided to seek a case, put it that way, and I'm not sure that that's what she was doing. In fact, based on her testimony and her mother's testimony, they sought out civil lawyers, not a criminal prosecutor. But here's the thing. Bruce Castor, the sitting district attorney at the time, realized, in his own words, he did not have a chance. He did not have a case against Bill Cosby, but he wanted Bill Cosby to pay Andrea Constant something. So he made a deal with Bill Cosby. Sit for a civil deposition. Anything you say in that deposition can never be used against you ever in this court. Well, a new district attorney comes along. Now, any deal that you make, a defendant makes with a prosecutor, is supposed to be binding, no matter who takes office later, unless there's a new crime committed. There was no new crime or alleged new crime. They just decided, Kevin Steele, who ran on the platform of, I'm going to get Bill Cosby, and Stephen O'Neill. Now, what complicates that even further, and a lot of people don't know this, based on published reports, unrefuted. In fact, I think Judge O'Neill did something so odd in that courtroom. He actually, after this report came out about an affair he had, he addressed his wife in the court, basically saying how wonderful she was and how much he loved her. And he did not dispute the report. Now, it gets even more complicated, right? Because Judge O'Neill ruled that Bruce Castor was not credible. How do you rule that the former district attorney is not credible? Well, here's why. The woman that he was having an affair with was the assistant to Bruce Castor, and the judge believed that Bruce Castor blew the whistle on the affair, told his wife. So there had been a grudge for years. So Bruce, the best thing that could have happened, and the one thing that should have happened, according to many legal experts, was that Judge O'Neill recused himself from, at least, if not the trial itself, but from making the decision as to whether or not Bruce Castor and his agreement with Cosby was legitimate. He did not do that. There was this animosity played out very well over, 2 years, Andrew, or more?
Yeah, over 2 years. Over a 2-year period, it was the animosity was there. And look, you hit the nail on the head, and great job, giving more in-depth information that mainstream media refuse to acknowledge or refuse to print because they were a part of the kangaroo court. They were the associates of the hangman, who was Judge O'Neill. Yes, Judge O'Neill did have that affair. The woman he had the affair with was the assistant district attorney of Bruce Castor at the time. She's now a judge in Montgomery County area. I think she's a district judge. But we have a sworn affidavit from Bruce Castor. Not only just sworn written affidavit, but a video affidavit of him acknowledging that O'Neill had a grudge, an axe to grind with him. We're not saying, Stacey, that a district attorney has pardon privileges. That's what we're not saying. But a district attorney can make a deal. this district attorney, Bruce Castor, gave Mr. Cosby a deal. And it's important for your listeners and your viewers to know what the purpose, why he was given the deal. Mr. Cosby was never charged with anything. He willingly now told the detectives, you could search my home. No search warrant was ever issued. They declined. He then sat with detectives for hours in his attorney's office in New York, Jack Schmidt. He also brought along the supplements that he takes and the Benadryl that he gave to Andrea Constant. Now, remember, she spoke with 5 very different law enforcement agencies, gave inconsistent statements. Bruce Castor realized that he did not have a credible witness. He just had an accusation. So he could not bring charges. And on the witness stand, he said, I sought out to make her wealthy. I think I did. That's his testimony on the witness stand. Well, Andrea Constant. So he forced, after he sent out the press release saying I would not be bringing criminal charges, 19 days later, Andrea Constant files a civil suit. Mr. Cosby waived his Fifth Amendment rights. He sits for a civil deposition for 4 days, never invoking the Fifth Amendment. He was truthful, he was honest, but not knowing that he was given a testimony that would be to his detriment. And it will form criminal charges and against him because a district attorney who could not win that election had to use Cosby to catapult his win and his political career, Kevin Steele. So he ran a Willie Horton style campaign ad, as you mentioned, saying, if you elect me, I will bring Bill Cosby to justice. And that's where we're here. We're here today.
Yep.
We're here today. They used the deposition already had, through the help of Constant's attorney, a script to give to women to parade them out so that they could come out and say, Bill Cosby drugged me, he raped me. They had just a signature script, and they created a signature pattern for Bill Cosby. And already, remember in 2014 in December, is well reported in the LA Times, she stated, Ocean 11 style script, extortion script, give me $100 million and I would not parade any more women out.
And Andrew, we also saw during the course of testimony from Gloria Allred and Lisa Bloom's clients, something else that really struck me as a reporter, as a journalist, and just as a court watcher that was so wrong, if you will.
Right.
We saw them instruct their clients when to cry, when to smile, while they were on the stand. It was unbelievable.
You thought you was watching a baseball game.
Yeah.
The catcher would give the pitcher the signal. Throw a fastball. They were giving hand signals like wipe your eyes. They were giving hand signals like sniff. They were giving all of these gestures, and it was acknowledged by our attorneys. We acknowledged what they were doing to the courts, and Judge O'Neill did anything about it? He did nothing.
Well, here's what else Judge O'Neill did that was shocking while the jury was deliberating. Think about this now. The person on trial, his name is Bill Cosby. Bill, he starts outside the jury room where they're deliberating. The judge starts whistling the theme song to Kill Bill.
Yes.
Shortly after that, the jury came back with guilty verdicts. Now, you can read into it as you will. But I just thought that there was something peculiar about the judge whistling Kill Bill very loudly outside the jury room, and then they come back. In fact, if you recall, Andrew, in the first trial, when the jury came back, and in fact, they came back a few times and said they couldn't reach a verdict, but when they came back, it was we were all given announcements that, hey, the jury has something, et cetera, et cetera. When they came back with the guilty verdicts, we were not alerted that they were coming back with a verdict. We were just asked to come back to the courtroom. It was so weird. It was so scripted, as you said. You really had to be there. And that's why when you hear people, I really appreciate it. We had Sinbad, and we hope that Sinbad is recovering. He had a stroke. We had Sinbad not long ago on the program, and I really appreciated what he said. In the sense that a lot of people have given their opinions without being there. A lot of people have given their opinions by reading mainstream media. Sinbad only said, listen, I wasn't there. I don't know what happened, but I do know that he's my mentor. And he said all of these great things about Bill Cosby. So he couldn't speak to that. He couldn't speak to it. So if you're not going to be able to speak to it from experience, from being there, from seeing this, then really let it play out. Today is going to play out at 9:30. Bill Cosby will finally get what we believe will be his first fair hearing. And that's with the state Supreme Court. The state Supreme Court generally doesn't take up these type of cases.
Right.
And they generally don't. There's a lot of cases they refuse. But they were really, apparently, really agitated with at least two things here. And that was the agreement that Bill Cosby and the former district attorney had. And of course, the 5 women who came forward with allegations from decades and decades and decades ago, never charged, never proven. That's what's bothering the Supreme Court. That's what we're going to hear today. The arguments will be that each side will get 2 minutes. And then the court will ask questions, and they'll have, Andrew, I believe, a minute to answer the question, or another 2 minutes to answer the question.
You know, you have 7 justices, so you know every justice is going to probably want to weigh in and ask a question. So that can, you know, you will see, and part of oral arguments, and I know a lot of people will become frustrated, but you will see interruptions of the judge when our attorneys speak. You will see probably, you know, a number of interruptions, and she might not get to finish her thought pattern. And you will probably see the same thing on the prosecution side, because it's also to get you in a frenzy, to get you to see if you're going to stay on point with your argument. That's part of it. It's like watching a debate almost, and you're trying to, you know, convince people why your argument should be taken as valid, or it should be taken as the Bible, so to speak. So yeah, it's going to be an interesting day. You know, let me point back on something, Stacey, with that first trial. If you remember, there was only one 404B allowed prior to that act, and it was Kelly Johnson. And the jury deliberated. We had an opportunity to talk to the jury foreperson, who was an older white female, and she, you know, she told us a couple of things. She said, "Look, we first reached a verdict. Now and the judge made them go back and said, no, you gotta go back and look at the evidence." You know, and that's why I call him the hanging judge. This jury deliberated for 50 plus hours and came back as a hung jury. But what the jury foreperson told us, she said, the judge first was extremely nice, and then he became frustrated with us. He ended up taking us out of a large conference room and put us in a very small conference room. We went from eating good meals to eating strambolis, and you know, you had people who were diabetic, people who had high blood pressure. So you go from feeding them one particular meal, a healthy meal, and now you're feeding them strombolis and pizza. And one of the jurors even got upset where they hit the wall and knocked a hole in the wall. So this judge was heinous. He had an out for Mr. Cosby. And he had a issue with Mr. Cosby just for being who he was and who he is today. And this judge also, let's remind people, his wife was behind getting Mr. Cosby's honorary degrees rescinded, because she's a professor at University of Penn, and he helped her with her dissertation on sexual assault. So her name is Di O'Neill. So all of these things that people were not made aware of, that took place during both trials, it's astonishing. And it was astonishing that we were able to get a hung jury at the first trial. And remember, we didn't put on a defense. We didn't.
That's a great point. I've made that point in writing about this case many times, and in talking about this case many times, that when you think about this, for those who jump to conclusions, anytime you don't put on a defense in a criminal trial, chances are you're being convicted.
Correct.
There was no defense. The Cosby team did not call one defense witness in that first trial. And as Andrew Wyatt just pointed out, that first jury really was leaning toward a total acquittal. But because of pressure from the judge, it ended up being a hung jury. That jury stood its ground. And one of the reasons, too, I suggest that they stood their ground, they were from Pittsburgh. They were from the other side of the state.
Mm-hmm.
One of the mistakes I believe that the great Tom Mesereau made was in the second trial was saying, nope, we're going to go with the jury right here. I think Mr. Mesereau remembered his great defense of Michael Jackson. And part of that great defense was picking a local jury whom the prosecutors in the Michael Jackson case did not calculate that Michael had such a connection with that Santa Maria community.
Mm-hmm.
But Bill Cosby, I think what Tom Mesereau might have considered and might have been thinking is that, well, we're in Montgomery County, right outside of Philadelphia. Well, it's a huge difference between Montgomery County and Philadelphia, where Bill Cosby grew up. And that was a miscalculation, Andrew, because we found, what did we find with the juries? The relationships was unbelievable. They
knew the DAs, they knew the police officers, they knew the judges in the courthouse. Look, I had a long conversation with Tom before he made that decision. And I told him I didn't think it was a good decision. And I've been publicly about it. I spoke publicly about that decision he made, because he did not understand the geographical landscape of Philadelphia and Montgomery County. When you're in Philadelphia, you're surrounded by North Philly, South Philly, West Philly, Kensington. You're surrounded by the Black people and the Italians. So you have a melting pot. Mr. Cosby never spent any time in Montgomery County. He just has a house at Elkins Park, but he grew up in Philadelphia proper. I felt like getting a judge, Tom would say, well, look at the counties that if the state Supreme Court would have to pick what county we get these jurors from. And you're probably going to get 1% to 2% of Black people. We didn't have to worry about the Black people or the color issue. Although we wanted Black people on the jury, whether we went to Erie, Pennsylvania, these people were not tainted by the media as though those people were in Montgomery County, and still showed that he was very popular in Montgomery County. He won that election there. So it was a bad move. I think Tom looked at Michael Jackson and he tried to bring Santa Maria, I think that's what Michael was tried, into Pennsylvania, into Montgomery County. And it just did not work. It wasn't the makeup for Bill Cosby. And those people's minds, in my opinion, those jurors' minds were already made up. They had already come to a conclusion. And a lot of people also were fearful. Most people dream when you live in Philadelphia is to get out of Philly and move to the county.
Yes.
It's better school systems. It's safer. The crime rate is lower in the county. So a lot of people did not want to go against the grain in fear that I have to live here. They now know my name and address. Who's to say that I won't be harassed by the police or by my employers? So I just think it was just a bad strategy move on Tom. And Tom, I admire him. He's a dear friend and he will always be a friend. But, in friendships, you have disagreements. And that's what I disagreed with him on.
Well, and I think as we've stated, you could have Perry Mason and Tom Mesereau and Johnny Cochran all in one against what you guys went up against with O'Neill and Steele. And I don't know that you ever win completely. At best, you might get what you got in the first trial, a hung jury, right?
You're never going to win. We wouldn't have never got a hung jury with this trial because first and foremost, they stacked the deck. They gave Judge O'Neill gave Kevin Steele an a la carte menu of 19 women to choose from, to get his 5 from. Mr. Cosby went into a trial thinking he was going to have a trial against Andrea Constant. He had a trial against 6 people, 6 women. It was 6 separate trials going on at the same time, believe it or not. And it's hard when the judge doesn't give the jury proper instructions to say that the accounts that you're hearing from these 404B witnesses, they're not testimony that you take to the deliberation room. However, there is a thing called human element. human behavior, the human mind. And it's hard for a human being to hear something happening to someone and not take that into their decision. So when you have women on a witness stand crying, for example, Janice Baker Kinney, you have this white woman who stated, me and my friend, we sought after the big black man, the big black buck, sending messages. They went after black men who were big and muscular and tall. And that's why we went after Bill Cosby. She stated, I've done LSD. I'm a recovering addict. I can't say that Bill Cosby ever raped me. I can't say that he ever sexual assaulted me. Yes, I had sex with him consensual. However, after hearing all of the accounts and seeing the women being paraded out and Gloria already contacted me, I began to believe that I repressed some things.
Yeah. Yeah.
How do you erase that from a juror's memory? You can't.
And you also had, it's what's interesting too, we talk about the 5 women, but the judge also allowed the 5 women to have witnesses. So you had, for instance, you had Janice Dickinson, and then you had her publisher back her up. So you had all of that going on. They had nothing to do with the Andrea Constant case. Andrea Constant had admitted that she had been in a relationship with Bill Cosby. She had followed him to Connecticut, to a hotel there. She got upset when she laid on the bed and he was too tired to do anything, right? And so she got upset. She left. Mm-hmm. She came back later. There was they gave each other gifts. There was kissing and petting. This was all admitted to.
But however, mainstream media negated that stuff, and I don't mind putting it out here publicly. We saw Stacey, well accomplished, distinguished producer Marianne Haggerty was NBC News, actually having people to be assistants to these women. NBC had people who served as assistants, taking these women out to lunch and making sure these women had car service, all through the aid of Gloria Allred. It was just remarkable to see how, journalists are supposed to be, not opinionated. You're taught to not involve your thoughts or your beliefs in something. Just state the facts. Tell the news. We saw true journalistic malpractice in this trial against Bill Cosby.
I like the way you put that too. I like the way you put that. Journalistic malpractice. I think that it certainly occurred on a grand scale in the Cosby trial. We saw Kevin Steele's PR person, can't remember her name off the top of my head. Kate. Mm-hmm. Yeah. We saw her huddle with a lot of these reporters on a regular basis, giving them talking points. And what shocked me, I covered the O.J. Simpson civil trial. Obviously, I covered the Michael Jackson trial and other trials. Right. And if you, as a reporter, you're competing basically, right, for the best story with the other reporters from the other news organizations. If you miss something, they was not helping you out. You missed it.
Right, you missed it.
In this case, in the Cosby case, the reporters traded notes. I saw it with my own. They can't deny it, right? I saw it with my own. They traded notes. This is okay. This is how we should put it. This is how it's gonna. Okay, that's how you're writing it. That's how I'm writing it. And I was just remarkable to
see, because remember, we're in a small courtroom, so yes. The reporters are sitting right in the back of me.
Yes,
and I'm turning back and I'm talking to various reporters. I was like, they were telling this one reporter said, no, you write this angle of the story, you write that angle of the story, and they were sharing their notes. It was the open book test of journalism, and it was sad to see, because Stacey, I come from the journalism background. I worked in the news industry for 12 years, so I was taught the old school way. Look, when I worked in the news business, I don't care who was running for office. I had no campaign signs in my yard. And I wasn't an on-air talent, but I worked in the business behind the scenes. And you're taught not to be a part of the storyline. But now, because of the world of social media, journalism now has really changed, where now everybody's opinionated. Everybody tells you their political affiliation. They tell you how they feel about a certain person. And it was just remarkable to hear these journalists take a side and say, "Oh no, he's guilty. He's guilty."
Yeah. Andrew, it's time to go into the courtroom, Andrew. Bill Cosby, Jennifer Bonjean we expected her to do the arguments for
Right.
Bill Cosby.
She's remarkable, man. She's a brilliant attorney. Happy to have her on the team, and she's on the team, believe it or not, because Mr. Cosby's youngest daughter, Evan Cosby, is friends with her, and their daughters are friends. And she lived in the Massachusetts area, so she's a great recommendation. Came to the team, highly recommended, and she's done a phenomenal job. And we wish her the best. Wish her the best.
And for those who may not know, Bill Cosby is not expected to be seen on this, but we are getting ready to go into session with the state Supreme Court in Pennsylvania.
Good morning. We welcome everyone to our December session, held again by WebEx in light of prevailing public health concerns. This is, by my count, I suppose, the fourth time.
Can we turn up the volume a little bit, I guess?
Yeah, I think individually on your own computers, you're going to have to turn it up the way they have it.
Our technical people and counsel work with those who are argued ahead of time, and we do very good to make it work. But you never know what might occur. So we've usually been able to work around those, so we'll do the best we can. Try to move forward with today's list. I conclude by reminding all of you, though, in any event, that we do have the benefit of good briefs with very few communications. So you needn't worry if you miss a point or if there's a technical issue, because there's nothing that you would argue that would be accomplished in your written presentations. With that, I'll call the first case.
First matter is the Commonwealth of Pennsylvania versus William Henry Cosby Jr. Representing Mr. Cosby is Ms. Jennifer Bonjean. Representing the Commonwealth is Ms. Adrienne Jackie and Mr. Russell Allen.
Good morning. In this case, the felon was convicted of aggravated indecent assault, stemming from an incident that occurred in 2004. Prior to trial, the felon moved to dismiss the charges, claiming that the prosecution had granted him immunity from criminal liability. He denied. During trial, the Commonwealth introduced 5 witnesses under evidentiary rule 404 to testify regarding their accusation of sexual assault against the felon for purposes of establishing the felon's common scheme of playing. The issues before the court are whether, 1, the testimony of the 5 witnesses regarding their respective accusations was admissible evidence under Rule 404, and secondly, whether there was a binding agreement between appellant and the Montgomery County District Attorney that would result in immunity from criminal prosecution. With that, proceed with the appellant.
Good morning, and may it please the court. In our system of justice, a defendant must be tried for what he did and not who he is. And yet, the prosecution has made no secret of the fact that it intended to indict Mr. Cosby's entire life. After failing to secure a conviction after Mr. Cosby's first trial, the prosecution shifted strategy, laying waste to the presumption of innocence, and telling the jury that Mr. Cosby's claim of defense could not be believed because he had done this so many times before. The prosecution forced Mr. Cosby to defend not only the charged offense, but 5 mini-trials, and vague accusations from countless Jane Does dating back to the 1970s. And while the public and the media were free to judge Mr. Cosby's guilt based on those factors, his criminal jury was not. And perhaps a limiting instruction served its purpose at Mr. Cosby's first trial. But there can be no confidence that it did its job at the second, where the jury was bombarded with prior bad act evidence. Indeed, half of the prosecution witnesses testified in connection with uncharged 404B allegations. Some of the allegations, the most damning ones, came from a deposition that should not have been admitted in the first instance on account of an agreement with the Montgomery County District Attorney not to prosecute Mr. Cosby, promise on which he relied to his grave detriment.
They both are Montgomery County did.
As argued in our briefs, none of the prior bad act evidence served a legitimate non-propensity purpose. But that aside, consensus surely must be reached that Mr. Cosby suffered unquantifiable prejudice where the PBA evidence or the prior bad act evidence overwhelmed his second trial, converting it from a trial on a single offense to a trial of his character. And with that, I would entertain any questions from the court.
Counsel, this is Counsel Justice Doherty speaking. Let me just zero in on the civil deposition. Even taking into consideration and finding is true that he, Mr. Cosby, your client, did not believe that he was to be prosecuted for the events involving Wisconsin. Tell me, when confronted with a question plausibly implicating criminal conduct, in any deposition, an individual has an affirmative duty to invoke their Fifth Amendment regarding other issues or potential other criminal conduct. Why was that not done by counsel for Mr. Cosby or Mr. Cosby himself?
I think that speaks to the agreement, frankly, that the agreement not to prosecute was linked to the willingness to give a civil deposition, which we know this in part from looking at the press release, which demonstrated that not only did the district attorney at the time, Bruce Castor, decline to prosecute, but he mentions in the press release that there was going to be ongoing civil litigation. So, and you also can look at Mr. Schmidt's testimony, who's testified that it was our understanding, it was our belief that the promise not to prosecute would be honored so long as Mr. Cosby agreed to sit for this deposition and give testimony and not invoke his Fifth Amendment right, which he did, again, to his detriment. And in hindsight, of course, we would have preferred to have seen a written agreement or something on the record that would have reflected that this was the arrangement that had been made. But I think the fact that Mr. Cosby actually sat, answered questions for 4 days, and I think it speaks to the court's point, that this is evidence in and of itself that he relied on this representation. No one would sit for a deposition and not invoke their Fifth Amendment right, guilty or innocent, if there was the possibility of criminal prosecution looming over your head. So the fact that he did leads to the only reasonable inference that he believed that in order to not be prosecuted, this was part of the agreement that he complied with. And as a result, to the extent that the prosecution wanted to use the deposition testimony, once they decided to prosecute him, that deposition testimony should have been off the table at a minimum.
Counsel Justice Baer, at the first trial, I don't think it's in our record, but it is properly before us. Was there any prior bad act testimony?
There was one prior bad act witness who testified at the first trial, correct.
Of course, you didn't take an appeal because that was not a conviction.
That's Your Honor.
I understand your argument. I tend to agree that this evidence was extraordinarily prejudicial to your client. But there's a trial court discretion component here. In your view, if the trial court had allowed one again, would that have been an abuse of discretion? Or if the trial court allowed two? And where do we as an appellate court draw a line between abuse of discretion and discretionary call, which perhaps we would have not made, but which would not powerful, we don't have the power to overrule?
Yes, understood, Your Honor. Our position is the trial court abused its discretion for two reasons. One, because not even one prior bad act witness served a non-propensity purpose, but also because the admission of 5 prior bad act witnesses was unduly prejudicial to the point that no limiting instruction could have cured it, and that these 5 discrete allegations from 15 to 22 years ago had such minimal probative value as compared to the danger of unfair prejudice that it seems clear that the court did not exercise discretion in allowing 5. So it's twofold. Our position is that there was no theory of admissibility that was for a non-propensity purpose. But even if this court were to disagree with that, at the end of the day, 5 witnesses, plus all of this vague testimony about Quaaludes and Jane Does that were just exploited to the hilt during the closing arguments, that frankly were just contorted from the deposition testimony in the first place, put Mr. Cosby in a position where he had no shot. The presumption of innocence just didn't exist for him at that point. And so I think the court abused its discretion in both of those ways. Thank you.
Counsel, this is Justice Donahue.
Good morning.
Good morning. Since you are not going to have time for rebuttal,
Yes.
I would like you to, for me, spend a little bit of time talking about why the evidence that was offered through these prior bad act witnesses did not go to establish a common plan or scheme for a signature crime, which is what I understand their purported use was.
Yes, Your Honor. So at the outset, I would say the common plan is in an act theory of admissibility here for 2 reasons. One, because the prior bad act evidence was not part of a single overarching plan, which I think the prosecution concedes. It also was an act because identity was not a disputed fact in this case. And the overwhelming authority from this Commonwealth and across the country is that signature-like prior bad acts, also known as modus operandi evidence, is relevant to prove identity. In fact, the text in this Commonwealth is that it must be so nearly identical to be the handiwork of the same perpetrator. But when identity is not in dispute, the evidence simply registers with the jury as propensity evidence. To put it very simply, where identity is a dispute, a modus operandi may be perfectly proper. Where identity is not in dispute, it just amounts to propensity evidence. And make no mistake about it, that is what the prosecution is asking this court to do, is sanction propensity evidence. And simply because the prosecution can shoehorn prior bad act evidence into some exception, it does not make it admissible, since it may not bear on a matter at issue in the case. But with that said, if any members of the court disagree with that analysis, and that may be the case, even if this court believes that the signature crime approach is the appropriate approach to this case and a proper theory of admissibility, the prosecution still does not prevail here, because the prior bad acts were general in nature insofar as they involved sexual misconduct of some type and the use of an intoxicant. They were not nearly identical as to the charged offense, at least any more nearly identical than they would be to, frankly, almost the majority of acquaintance assaults or date rape situations, where we know that intoxicants almost invariably play a role in those types of assaults. But if you want to get more granular about it, in this case, we have prior allegations, again, 15, 22 years old prior allegations, that involve a number of distinctions from the charged offense. I think one of the most astounding ones is the nature of the relationship. You cannot compare the relationship that Mr. Cosby allegedly had with these 5 other women that he did with the complainant. This was an 18-month relationship. This was a relationship that, at least by her own testimony, was built on friendship. They exchanged gifts. They spoke regularly. This notion that he was mentoring her, well, I mean, anybody who comes in contact with Bill Cosby is going to sort of, given who he is, could perceive that he would be a person who's wise and would be able to give you advice. But this is not a scenario where he sought her out or she sought him out for some to advance her acting career or a modeling career. This was a chance encounter. He brought her into his inner circle as a friend, introduced her to people he knew. He traveled to places with her, where New York, Connecticut. So the nature of this relationship was very different. In the 5 prior bad act cases, one woman had not even been invited to Mr. Cosby's home. She just came with a friend, and she was not an actress, and she didn't. This was just a woman that showed up to come socialize with Mr. Cosby with their friend. The other women had met him once or twice. So again, the nature of the relationship, I think, is a marked difference between the prior bad acts. We also have very different sexual type of contact. One of the women, Ms. Loveland, testified that she doesn't recall any sexual contact other than some bizarre behavior where he allegedly stroked her hair. And some women describe, intercourse where other women describe that there was something that didn't involve penetration. So the sexual acts themselves were very different. The nature of the intoxicant was different. In some cases, like Ms. Baker Kinney, she said, I took the Quaalude. He offered a Quaalude to me, I took it.
Yep.
There's no evidence whatsoever that anybody else was given a Quaalude. Even among the other 4 prior bad act witnesses in the charged offense, for as much as Quaaludes played a role in this case,
We just spoke about her.
perspective,
Yep.
it just they will concede they have no evidence that Mr. Cosby.
She's doing a wonderful job.
She is.
She's doing a great job.
The only person who speaks about a Quaalude is
She's answering the
Ms.
questions,
Kinney, who said he
and she's
offered me
breaking
Quaalude
down the
and I
account
took
for
one.
each prior bad act.
Yes.
Indeed.
Good morning.
Good morning. Let's assume we accept your argument on prior bad acts, that it was error to introduce it. Could you address the harmless error question? Could this possibly have been harmless error?
It could not have been harmless error, and I think we need only look at the first trial to get our answer to that. It is clear that the prosecution wanted and needed propensity evidence, but they had no right to it. You don't get to make up for weaknesses in your case by bombarding a jury with rank propensity evidence. That's not fair. And frankly, the prosecution's case, the evidence was ample. They didn't need this evidence. They had the complainant's testimony. They had corroboration. They even had an expert who was able to rehabilitate any cross-examination. And with that, the first jury still could not reach a unanimous verdict. And as a result, I don't think that this is a case where there was overwhelming evidence of guilt. And I think we have the benefit of this first trial to tell us that. And yet, the prejudice, again, was extraordinary in this case. And no curative instruction could have solved it. I think the Third Circuit said it best when it commented that when evidence of this magnitude is presented to a jury, it is most difficult, if not impossible, to assume the continued integrity of the presumption of innocence. And to put it, yes.
Now, this is Justice Doherty again.
Yes.
Let me return to the civil deposition because I struggle. It appears that your argument is based on promissory estoppel, correct?
Correct.
So again, when we're looking at the parties with regard to promissory estoppel and each individual factor, the concern that I have is here, as you indicated in your opening, they're trying to dissect or look at his entire life. And that being that, I assume you're implying that he's a celebrity, and therefore this is even a harsher look at him. With that in mind, my concern is how are we to accept one of the second prongs of promissory estoppel as justifiable reliance on the inducement when we have to look at this individual? We're dealing with an individual who's knowledgeable of the legal system. He's in entertainment. It's not as if this is his first advancement or use of
Not logical of the criminal legal system. And that's why
Right.
we have attorneys. That he's never been in a criminal situation to be knowledgeable of it.
for which he signed, indicating that order to find justifiable reliance of an individual who's intellectually, at least legally superior than the average person. History, as you brought forth in your argument.
How did you
How
say
do you-
somebody is because they're a celebrity, they're legally superior?
That's surprising.
Yeah, very surprising. That's a very surprising statement. A question he's posing.
And yet, affirmatively refused to invoke a Fifth Amendment. I'm struggling with your argument.
And I understand that, Justice. I think I would disagree with one premise, which is that the assumption that, and with all due respect to Mr. Cosby, that he is particularly savvy about the law, or that he has an understanding of these things. I think high-profile people often rely almost to their detriment
Right.
on legal advice.
Yep.
They have a
They
lot
all
of
do.
legal issues, and they defer many times to their attorneys who tell them, this is the deal. You know, this is part of the agreement. You will not be prosecuted. Go sit down, cooperate. You cannot invoke your Fifth Amendment right. And he relied on that. And I think that this court's decision in Civitich really helps guide us here, because in that case, you had two defendants who were arrested, and even with the assistance of their counsel present, brokered a deal with a law enforcement officer who said, listen, if you tell us the source of this contraband, we won't prosecute you. And again, here are defendants, I don't know how savvy they were, but they were there with their attorney, and the attorney said, yes, go ahead and tell them that. And naturally, this court ultimately concluded that it's the district attorney's job to decide who prosecutes, not law enforcement officers. But the court still determined that that evidence should be suppressed because he relied on that. And as a matter of equitable principles and fairness, I think that we would have to assume that for Mr. Cosby,
You can't have a set of rules for celebrities and a set of rules for you and me.
Yeah, for layman people, it's impossible.
but I think the fact that he did sit and gave the testimony, the only fair inference is that he did rely on the representations, and that it was done with the assistance of his attorney who testified. I understood through his criminal counsel, and I understood through the criminal counsel from the district attorney that this was connected. He had to testify in order to not be prosecuted. And that's the screen can answer that.
I'm sorry, I didn't mean to interrupt you. Just
My
here.
apologies.
I want to follow up on Mr. Doherty, and then I have an independent question. And I don't mean to nitpick, but there's nothing in my preparation that indicated that Mr. Cosby has ever indicated in his testimony or his protestation that he relied upon the alleged deal with D.A. Castor. In the trial court, and I noticed Smith, who was attorney Smith, who was attorney at that point, not credible, found that his testimony was not persuasive. And I can't recall, indicated that he negotiated a deal with the National Enquirer and this settlement and et cetera, et cetera. He just didn't believe that he had done this. And again, the first question I asked you was trial court discretion. Here again, you fall under the constraint of trial court determination of credibility, which is binding on us. But doesn't that sort of get you to the wrong side of Justice Doherty's question?
Well, I think you are absolutely correct that this court owes great deference to the trial court's credibility findings. They are not, however, unassailable. And I believe that the dispositive facts in this case, the ones that are not disputed, still lead us to the conclusion that at least the deposition must be suppressed. And those are that we know that Castor chose not to prosecute. We know that. Whether that promise was intended to bind future prosecutions, I suppose, is a credibility determination that the court resolved against Mr. Castor. But we do know at that moment he declined to prosecute. He represented that in the press release, and that it was bound to or linked, there was some nexus to the civil case. And again, I can't create a formal writing that didn't exist. It just didn't exist. And again, we can look in hindsight and wish it did. I think we all do. But I think the reason it's troublesome for us is that we can't wrap our head around the fact, why would somebody sit for a deposition with prosecution looming over their head in such a serious matter? And I think while that may lead somebody to a different conclusion, for me it leads to the conclusion that, well, clearly there must have been a understanding and a confidence that if he did so, there would not be a prosecution. And that is, I guess, the best way I can answer that question.
I think that's fair. Let me ask you one last question. I hope I'm done. You, as part of your able presentation, detailed the nature of the relationship between the defendant and the victim. And one of the exceptions in 404B is absence of mistake, excessive history. Why isn't it reasonable that the evidence of the prior bad acts comes in to show that Mr. Cosby was not mistaken, that this was a consensual relationship?
Well, I would point out that using absence of mistake to show some type of mens rea, if you will, because that's what we're talking about, is unconventional, to say the least. There's a dearth of authority in this Commonwealth and elsewhere that absence of mistake is an exception that applies where the physical elements of the crime are not in dispute. You usually see it, of course, when a defendant says, well, my conduct was an accident or it was a mistake. And that's sort of the traditional scenario. Here, the prosecution is using it really for a novel idea that it allows us to look into Mr. Cosby's mind and determine whether or not whether he could have mistakenly assessed her ability to consent. And our position is, and if the court, I'm sure the court has read the briefs and will, Professor Winklereed wrote an entire article about the use of prior bad act evidence for mens rea purposes, and how it's really kind of a slippery slope because it's not as predictable, the mental component. Just because someone exercised a particular intent 5 times before 15 years ago does not necessarily mean he exercised that same intent or was under the same belief system. So we'll say that. With that said, there is authority from Commonwealth versus Tyson out of the Superior Court, which, for the reasons we've addressed in our brief, we have said we believe is wrongly decided. But apart from that, it's our position that it is highly distinguishable because, unlike the defendant in Tyson, Mr. Cosby had not been accused of those prior bad acts before the incident with Ms. Constant. So one of the focuses that the court had in the Tyson case was that there the defendant had been accused, he had lodged a consent defense, he had been prosecuted, so he certainly had knowledge. He suffered the penal consequences of his behavior before, and he was on notice that when he had this similar encounter, that he should have known better. But here we have a very distinct scenario where Mr. Cosby did not face any of these accusations prior to the charged offense. It came after the charged offense.
And that's what makes the 404 be murder.
We don't know whether
Mr.
Cosby would even consent as to those
if you've never been
prior
charged
acts.
with no accusations,
Silent on it. He could
I
say,
didn't know,
I don't know who
and they
that
just
woman
bring
is.
out
I never met
women.
that woman, or we never
Yep.
had any sexual relationships. The record is simply silent on that. So
That's it.
I think to sum up on this point, using absence of mistake as an exception, or to use prior bad act evidence to show a mens rea in this case, which is what the prosecution is trying to do. It has a number of pitfalls that are identified by Professor Winklereed. It's just not as...
Counsel, Ms. Bongini, this is Tom Saylor. The professor concludes very tellingly that the trier of fact can reason from the starting point of the uncharged crime to a conclusion about the mens rea of the charged crime only through an intermediate assumption about the accused character or perpetrator. That's the difficulty with this approach, isn't it?
Yes, it is, and that
That's
is,
ably carried. The jury is going to have to make that leap, and that's the overtly difficulty with applying this doctrine.
that's absolutely right. That the jury has to make a intermediate determination about tendency or disposition, that because he acted with an alleged mens rea in the past, he had a tendency or disposition to do so on the charged offense. So in that sense, that is why, frankly, prior bad act evidence just doesn't really work very well when looking at mens rea types of issues, as opposed to issues that involve physical acts, which are far more predictable.
Now, can I ask you if you could sum up in a word or two as we're going to move to the Commonwealth?
Yes, Your Honor. Thank you very much. I would just point out that prosecuting agencies in this Commonwealth and states across the nation have chipped away at the general prohibition on prior bad act evidence for decades. And with this case, they truly seek to obliterate it. This court should rule to protect the time-cherished rule, not just because it's Bill Cosby or to right a wrong in this case, but because the constitutional guarantees of the presumption of innocence, the burden of proof, and even due process that frame our criminal justice system are at stake. And I thank you all.
Thank you. We'll hear now from the Commonwealth.
You did a great job.
Good morning,
You
Chief
did a
Justice
great job.
Saylor, Justices of the Supreme
Yeah.
Court. Mayor
Better than what we
Court,
saw in
Adrian
the series.
Jaffe, on behalf of the Commonwealth, I will be arguing the prior bad act issue. My colleague, Deputy District Attorney Fallon, will be arguing the alleged non-prosecution agreement. Your Honor, the prior bad
Why
act.
is that? Is it why do we need two lawyers?
Well, we filed a motion to split up the argument, and that motion was granted. So since I've been working on the prior bad act since the inception of this case, and Mr. Fallon has been working on the other issue.
These are
that's
the
why we
same
submitted
two
a
states
motion.
that did it last year. And they split it up last year, Superior Court.
The prior bad act evidence in this case, the defendant's drug-induced sexual assaults of 5 women, was relevant under 3 separate grounds. First, it was relevant under the absence of mistake exception under 404B to rebut a defense. In this case, the defense was consent. That is, it had a tendency to prove that the defendant was not mistaken about whether or not Andrea Constant was conscious enough to consent to any sexual contact. The evidence was also admissible under the common plan or scheme exception. The defendant engaged in a years-long signature predatory pattern of seeking out and intentionally isolating young women so he could intoxicate them for the ultimate purpose of sexually assaulting them. So his
But
plan
these
was
wasn't
to
young
target
women.
Young women to eliminate.
But see, that's what they did. They even Constant, they painted her
Counsel, I
and made
apologize
people believe
for
that she was
interrupting you,
a
but you
student
say
at Temple.
the
She
5
wasn't
women
a
were
student, she
sexually
was an
assaulted.
employee.
It's my understanding that the last individual, the young woman that was interviewed for a part on the Cosby Show, there's no allegations of sexual contact. It's that she took
Charlene
medication,
Watson.
fell asleep, and woke up.
Yes, Your Honor.
So
And
share with me, how can you represent that there was sexual abuse on that person when the records evidence indicates just the opposite?
Your Honor, I would submit that the signature was isolating and intoxicating young women for the purpose of sexually assaulting them. And Lisa Loveland, you're correct, Your Honor. She did in fact testify that she has no recollection of being sexually assaulted. She has no recollection of what happened after the defendant gave her a drink. She drank it after the defendant asked her to sit in between his legs on the couch, which she deemed to be odd and inappropriate. And then he began stroking her hair. Then she basically passed out and was unconscious until she woke up 2 days later in her apartment. But the bottom line is that the part of the signature
She
is
woke
the
up 2 days
entire
later.
contact and the conduct between the defendant and these victims. And the
Ms. Jaffe, Tom Saylor, but that conduct you described, the steps, the young women, there's literature that says that's common to 50% of these assaults, thousands of assaults nationwide.
Your Honor, it's the mentor-mentee relationship. It's the fact that the defendant was built trust in his victims because of their mentoring relationship, because of
I understand that, but you see, if that was the case, it'd be maybe you dispute the literature, but in the briefs they cite treaties and literature that says that's common to 40 or 50% of these assaults nationwide that number in the thousands.
Well, perhaps it is true that 50% of sexual assaults are drug-induced sexual
So
assaults.
how can that be a common scheme?
According to what's in the defendant's brief, there's been no evidence at trial as to any statistics, and I would submit that's not part of the trial record, so that shouldn't be considered by this court. But, Your Honor, the defendant engaged in a pattern of seeking...
Well, you brought it up.
But that's what they did in the trial, Stacey. They were able to get away with this because they had a judge who was part of their system.
And because he held himself out as a public
He was their teammate.
he was
And remember, the judge coached
the
him.
defendant's presence because he invited them to the location within his control under a guise. And each incident occurred again in a location.
I'm with Matt Herndon Sr. here. 2 days later, come on.
Right.
People carry out his plan.
Who wakes up 2 days later and don't go to a doctor?
Waited until they were unconscious or otherwise unable to consent to any sexual assault, and then either sexually assaulted them, or in the case of Lisa Loveland, he engaged in what I would submit as untoward sexual conduct, inviting a young woman to sit in between his legs and then starting to pet and stroke her hair.
Counsel, this is Justice Donahue. What are you describing? A signature? A signature crime? Is that what what you're describing to us? Because
Your Honor, I am.
Let me just.
I apologize.
Asking the question. The assault that took place here, the alleged assault that took place here, took place in the defendant's home after an 18-month relationship with with Miss Constant, after meeting her mother, after going on trips with her. I mean, you know, if you're talking about a signature, you better incorporate all of the facts that we have in the case that's on trial with what you are offering as a signature. Because frankly, I don't see it.
Your Honor, certain differences. Well, let me say this first. Miss Constant was not the only victim that the defendant had a lengthy relationship with. He had a several years long relationship with Lisa Loveland. He had a relationship with Janice Dickinson. She had been to his apartment in New York prior to the assault.
There was no
and he sought
relationship.
to mentor her. He also had a relationship
Flew her
with
from
Shalon
Lake
Lash.
Tahoe
He had
for
spoken to
1
her
week.
grandmother on the phone. He had come over to Shalon Lash's house for dinner. And he also had a relationship with Heidi Thomas. He spoke to her on the phone on numerous occasions. So it's not true that he only had a friendship or
There's not a
relationship with
connection
Andrea Constant. And in any event,
to
Your
a
Honor,
predatory
the actual relationship
rape.
is just one of many factors to take into consideration in making a determination as to whether or not
To alleged
something is a
predatory
signature.
rape.
There are certain distinguishing factors that are inconsequential to whether or not a crime is a signature or whether or not absence of mistake applies. That is, whether or not the defendant was mistaken in assessing Ms. Constant's ability to consent to a sexual assault. And I would submit that the absence of mistake exception, which was the main exception that we proffer this evidence for, has a lesser threshold of admissibility than does the common planner scheme. Whereas the common planner scheme, admittedly, as is pointed out in several opinions from this court, and as the defense points out in his brief, there is, in fact, some conflation between in common planner scheme. For instance, whether or not it's being admitted solely to show a common plan, or whether or not it's being admitted for identity purposes.
Can I jump in, counsel? Can I jump in on that for a moment? You've referred to an alleged signature aspect. Identity's not an issue here. So where are you going with this signature allegation? That's number one. And number two, with respect to your repeated argument about absence of mistake, how does that factor in here when Cosby never argued that he made a mistake or that he made an accident or something like that? He argued consent. Can you answer those two questions for me?
Sure, Your Honor. In terms of consent, I would submit that absence of mistake is routinely has been admitted in numerous cases or several cases in this Commonwealth to demonstrate an absence of consent, and I would submit that was the defense here, an absence of consent. And numerous cases, such as Commonwealth versus Tyson, have allowed evidence to come in to show absence of mistake. And in that case, Commonwealth versus Tyson, the defendant was on trial for rape of an unconscious person, and a prior bad act of a rape of another unconscious person came in, and the Superior Court, sitting en banc, found that that was in fact admissible to establish a lack of consent. And also another case, which was not cited in my brief, Commonwealth versus Kiersgaard, that was a 1990 Superior Court case. That was a situation in which a defendant was on trial for raping a teenager, and evidence came in of a prior rape of a teenager came in for absence of mistake to show that he was not mistaken as to whether or not the victim consented. So there are cases in this Commonwealth that allow for absence of mistake to show a lack of consent. And in any event, Your Honor, admitting other act evidence to rebut a defense is a staple in Pennsylvania jurisprudence. And the effectiveness of the rebuttal here is enhanced by a distinct pattern of similar crimes indicative of the common conscious design here. For instance, in Commonwealth versus Buskowski, that was the opinion of this court. It was a bathtub drowning case. The defendant was on trial for the murder of his wife, and incidentally, his prior wife died the same way in a bathtub drowning. And in that case, the court found that the evidence was admissible of the prior wife's drowning under the absence of mistake exception, to rebut the defendant's contention that the act was the result of a deliberate act. And in Commonwealth versus Hicks, Your Honor, as well.
We still have yet to show a
that was a
pattern.
homicide case, which I'm sure this court was aware of.
And her argument is all over the
And
place.
in that case, one of the reasons why the prior bad act evidence.
Yeah, Ira Mosley says she's lost her thought and is now pontificating, and she's right.
I didn't even know. I said it before Ira, so thank you, Ira. We're reading minds, but great minds think alike.
Of the defendant. So what we're doing here in proffering this prior bad act evidence.
You know what? That's why I'm so happy and appreciative in NCA, you, Dr. Taylor, and Norman, for giving us this opportunity. Because now the public get to hear the facts and get to see how this is a sham. Of course.
Right.
I'm not saying it because I represent Bill Cosby. You know, sometimes I have to put on two different hats that I represent people. I have to put on a hat of saying, okay, maybe something happened and maybe something did, and the truth is in the middle there. We've been here. We've seen this. That was not allowed.
He's saying he was perhaps mistaken in assessing her ability to consent.
No, he didn't say that.
The same thing.
He wasn't asserting that.
You can't.
I mean, he was asserting consent. In order to
Yeah, Ira's right.
I agree, Ira.
Right.
Incompetent, irrelevant, incoherent.
Defense into, oh, now we're going to prove that there wasn't.
Yeah, and that's you right there too.
Right. You're right there, man. Yep.
Totally different propositions.
Well, with all due respect, Your Honor, I don't see them as being different. However, also, the evidence was also admissible under absence of mistake to show that Andrea Constant was not conscious enough to consent.
Now, let me ask you this, counsel, before.
Since when does Benadryl make you lethargic?
Why did you need this evidence? You had you had the complainant who was capable of testifying, who did testify.
Yeah, Sean Teal, you're right.
The
Right.
question in this case was, who is the jury going to believe? The complainant who did testify, or the defendant, who had a different version of what occurred here? Why did you need prior bad acts evidence at all?
Your Honor, it was needed for several reasons. Number one, it was needed to corroborate the victim's testimony that she did not consent. In order to convict a defendant of aggravated indecent assault, the Commonwealth had to prove that the defendant engaged in non-consensual
Basically, they had no
penetration
case.
of Andrea Constant's vagina. Thus,
This
as
is
I
a
indicated,
campaign
the
promise that
main
he had
issue
to make
was
good
consent.
on because Look at the
Without this
millions of
evidence, the
taxpayers'
Commonwealth
dollars
would
in
have had to
Montgomery
largely
County they
rely
can
on the
spend to
uncorroborated
try this
testimony of
case.
Andrea
You
Constand
know, one in
regarding
a
the
hung
lack
jury
of
and then come
consent.
back the second time.
And Tyson
Millions
made
of dollars.
clear that this case,
And now
or this
people, because of a
exact
pandemic
scenario,
who never
created
knew
a
was on the
heightened
horizon,
need,
lost
noting that if
jobs.
the
And
evidence in
look
that
at what
case
those
was
dollars
excluded,
could
the
have been doing
Commonwealth would
that
have to
whole
rely
with
solely on the
Mr. Costa
uncorroborated
and the
testimony
sham
of
court,
the
sham
victim to
case.
counter the defense consent of consent. Now, I will say there was other corroboration
See,
of Andrea Constand's testimony, but in terms of consent, there was no other corroboration of her testimony. And in addition, Your Honor, the
Miss
victim.
Jaffe, excuse me, but you really, I think, you focus on the lack of consent on the part of the victim, but you're really trying to demonstrate appellant's knowledge of that lack of consent. And that was the argument of the appellant, don't you see, when you use that doctrine, absence of mistake. And, you want to inject that before the jury to show that the defendant lacked knowledge of the lack of the victim's consent. And I come back again to the problem with that type of testimony, legally and within the literature. That's going to require a jury inference into the appellant's mens rea, which is really what you're focused on. What was the defendant's state of mind? And I'll read you again that state. The trier of fact can reason from the starting point of the uncharged crime to a conclusion about the mens rea of the charged crime only through an intermediate assumption about the accused character or propensity. And that's the legal issue that confronts this court in terms of the sanctity of the verdict.
Well, Your Honor, I don't think that's an inference that needs to be taken or adopted because the whole absence of mistake, it's coming in to show the lack of consent. And the consent.
No, it's coming in to show the mens rea of the defendant with respect to lack of consent.
I would submit that it's coming in to establish the actus reus because part of the aggravated indecent assault, the actus reus of it is not just the digital penetration, but it's the digital penetration without the victim's consent. That's part of the actus reus. And to bring in absence of mistake, I would submit as simply demonstrating that Ms. Constand was not consenting or could not consent because of the intoxicants that were provided to her.
Ms. Jaffe, it's Justice Todd. You referred to, when you were discussing the prior bad acts, I thought I heard you refer to them as prior crimes. Did you do so?
I don't know if I did. It was inadvertent, and I generally say prior bad acts because, and I'm well aware of the rules. It doesn't have to be a conviction in order to be a prior bad act. It can be crimes or other acts, and in this case, there are other acts. I've made no. If I did make an assertion that it was a crime, it was inadvertent, and I apologize.
That's all right.
But I will say that there doesn't need to be a conviction prior bad acts to come in, as the title of 404B makes clear. Other acts sufficient.
Any of these prior victims report, prosecute, or go to court in any way over the incidents?
None of them went to court anyway. In terms of reporting, they did not report the incidents to the authorities for many years afterwards. However, many of them did in fact report them to some people. For instance, Chilan Lasha, she was the 17-year-old that the defendant intoxicated and sexually assaulted in a hotel room. Immediately afterwards, she drove to her guidance counselor and told her guidance counselor what happened. Janet Dickinson, she confronted the defendant the next day, actually, and basically said, "What the heck did you do to me?" And then after that, she in addition, she told like her publicist, and she was an actress, she told other people, including Dr. Drutinsky, when she was on Celebrity Rehab show with him. This was a couple years after the incident. Well before the Andrea Constand incident. So she told her publisher when she wrote a memoir, and in fact she wanted to include it in her book. However, after speaking with the legal team, they said, no, we can't put this, that he raped you and intoxicated you. And that was years and years before the assault came out. Several of the other prior bad act witnesses, one of them, when they went home, they told their roommate. Another one told their sister. But in terms of reporting it to the authorities, no. And as Dr. Ziv testified, she was our sexual assault victim behavior expert. A lot of times these people don't report right away. And she explained all these rape myths that the defendant sought to debunk in its cross-examination of Andrea Constand. So she explained why they don't.
Okay, they've given her way too much time.
Yeah, way too much time, especially to have two
sexually
people.
assaulted me after intoxicating me.
Especially to have two
That's why
people.
they didn't go to the authorities.
And she still has not validated her argument. And she's not answering the question.
Dating back as far as 37 years ago to 1984 with Heidi Thomas, and how that is probative of current.
Okay. First of all, Your Honor, I do want to clarify something. I know you're saying 37 years back, but the time is from the time of the incident to the time of the Andrea Constand assault, not the time of trial. So they were actually.
I think Attorney Bundy deserves more time.
The assault on Andrea Constand was in 2004.
Even though we don't think that's going to happen, but I think the burden of proof, at this point seems to be on the prosecution.
15 to 22 years in its brief. But the assault on Andrea Constand occurred in January of 2004, so you don't count January. So I will answer your question, but in terms of 14 to 24 years. First, I want to point out that there is no right line for what constitutes remoteness. The determination should be made on a case-by-case basis based on the unique facts and circumstances of each case. There has never been a case that unequivocally says 10 years is too long, 20 years is too long, because you have to consider the facts of each case. And focusing solely on the time lapse is improper because remoteness is only a single factor the court is to consider. And importantly, the
time limits are
time
necessary.
period is inversely proportional to the number of similarities between the incidents. And here there are abundant similarities, as I detailed, and I will be happy to detail them again, but they are set forth in my brief. And I also want to point out that numerous cases have allowed in prior bad acts for the time frame around the same time of this case. For instance, in Commonwealth versus Lucktish, that was a Superior Court case, the court allowed in 19-year-old sex assaults, and they were sex assaults going from 19 to 14 years before the current assault. And in that case, the court also let in another sexual assault, eight years before that. And Commonwealth.
Counsel, I apologize. I understand the case, so I understand. I guess the question or concern that I have in Pennsylvania jurisprudence, what you're advocating is that 3 decades of an alleged prior bad act is admissible in a trial because there's no ceiling as to the staleness or remoteness. Yet we have to balance that against our own rule 609 of evidence, in which the use of a conviction is considered stale in the impeachment of a witness, unless there's the other argument, unless it's more probative. So how is it that we are to digest the use of an alleged act is admissible 14 to 37 years later, yet we don't look as a trial lawyer and as a trial judge? I'm sure you, as a trial lawyer, have been exposed that when you try to introduce a stale conviction, it's objected to and usually sustained. How is it that what you're really asking us to do is to place an alleged prior bad act being a superior position in its introduction into a trial as opposed to a conviction? I'm really struggling with that position.
Okay, and I'd be happy to answer that, but I first want to say I would disagree that it's routinely not allowed in if it's over 10 years old. And a case in point was in this case, one of our prior bad act victims had a prior conviction that was over 10 years, and that was allowed in by the trial.
You're going to use that?
She's struggling, Stacey.
We're talking about
Struggling.
A single conviction. Here we have a recurring sequence of events, and that's why it's important when you're considering remoteness. You don't consider simply the one prior bad act in isolation and only in relation to Andrea Constant, the case law makes
It's interesting
clear
that
that you must consider them
that
all
Steele
in
has not
relation to
taken
each
part
other.
in any
So
of
in this
these
case, the ones that were introduced,
oral
we
arguments.
had two in
Yeah.
1982, one in 1984, one in 1986, and one in 1989. And again, I want to stress that you don't look at these in isolation, and this shows that there was a recurring sequence of acts by the defendant over a continuous span of time, as
How long has
opposed
she
to
been
random
going that
and
state?
remote acts, such as
This is 24 minutes for her.
conviction for
And how long did
Andrew, Jennifer had 30 minutes.
14 to 21 year gap. When the
So
court
they're
had
going to
this
divide
evidence to
two
consider,
arguments, and then
the
you're going to
gaps
get
were
this
less
other
than
guy
14 to
who's going to
21
show up.
years
What, going to
because
give
we
him another
proffered
20?
19 witnesses. And when the court made his determination as to whether or not this evidence was relevant, the court had all 19 of those witnesses to consider. So he had the time frames of all those witnesses that closed up some of the gaps to more sufficiently demonstrate this recurring pattern or this recurring sequence of events of the defendant isolating, intoxicating, and then sexually assaulting young women.
Counsel, that segues me into one additional question. Let's talk about that. My understanding of the facts of this case was that the Judge O'Neill, permitted the Commonwealth, out of those 19 witnesses, to choose any 5 and then introduce them, correct?
No, that's not correct, Your Honor. The court allowed the Commonwealth to choose 5 out of 8. So we had 1 to 19 listed in chronological order, 19 the closest to Andrea Constant's assault. He said we could choose any 5 from number 12 through 19.
Counsel,
While he said that, he also stated that he believed the evidence was all relevant. All 19 of them were relevant. But in only letting us bring in 5, he was weighing the probative value of this evidence against any potential for unfair prejudice.
counsel, justice there, and again, I'm just trying to follow up. Most of the argument today has been whether or not this evidence falls under 404B and it's admissible at all. But I think I started this argument an hour ago by asking your worthy opponent about abuse of discretion. And I'm still there to some extent. Did you advocated putting all 19 in? Is that correct? Oh, I lost you.
I'm sorry, can you hear me?
I can't hear you now. You advocated putting all 19 in.
We did.
150? Is there any point at which we're not trying whether or not the defendant assaulted the victim, but rather trying whether the defendant assaulted one of the other 19, 8 even? And again, I recognize abuse of discretion is a broad standard, but you can still get to the point with evidence that's terribly probative that it's just too much and that this defendant did not have a fair trial.
Well, Your Honor, again, like the
It's admissible, but the amount of it is such that the weight was conflated the issue from whether this defendant did this crime to whether he did the other 5, 18 and 19.
Well, Your Honor, in addition to the judge only allowing
Only?
us to present 5, the court kind of acted as a gatekeeper during trial. After the first prior bad act witness, the Commonwealth, the defense moved to preclude that, to strike that testimony, and then she moved to preclude the next testimony. So the court was essentially revisiting the ruling, and he said on the record, you're allowed to have up to 5. So if he made the determination what would have been unfairly prejudicial or what was too cumulative, and that's what the job of the trial court, to exercise his discretion and do that. And importantly, there's no bright line rule that 4 prior bad acts are too much, or 5 or 6. It depends on the facts and circumstances of each case. And there have been several cases in this Commonwealth that have allowed in more prior bad acts. For instance, in Commonwealth versus Frank, a Superior Court case, which I cited in my brief, a therapist was on trial for sexually assaulting a young boy, and the court allowed in 6 prior bad acts to establish a common plan or scheme. And then in Commonwealth versus Arrington, which was a case from this court from a few years ago, Justice Baer, I know you wrote the opinion, and Justice Todd, you joined in with the majority opinion. In that case, that was a homicide case, and the court allowed in prior bad acts from two previous girlfriends and then some prior bad acts from a man. But each of those girlfriends testified as to multiple instances of abuse, and the man testified as to several instances of abuse. So I believe about 12 instances of abuse came in. So although in that case there were only 3 witnesses taking the stand, there was about a dozen separate instances that were described. And the same with Commonwealth versus Luftish and O'Brien, what I cite in my brief, sex assault cases. In them, only, I think, 2 prior sex assault victims came in. However, they testified as to numerous assaults that were committed on them by the defendant. Here we only have 5 prior bad act victims. And while the defense says the prior bad act victims took up half of the testimony, that is not true. There were 25 witnesses that testified at trial over the course of 10 days. We had 5 prior bad act witnesses. That's it, aside from 2 corroborative witnesses that took the stand for about 3 minutes each. That was 2 days of a 10-day trial.
Ms. Jaffe, we're going to hear now from your colleague, Mr. Fallon, because we want to conclude this argument, which is gone on for a while.
Your Honor, if I might just take 2 minutes to address harmless error very quick, because I know that was brought up.
Hold up.
Yeah.
If I may, it's our position, Your Honor, that even if for some reason this court finds that the evidence, the prior bad act evidence, was not admissible, I would submit that any error was harmless in light of the overwhelming evidence. We had Andrea Constand's testimony.
None of them trying to protect themselves from a lawsuit.
Pills rendered her incapable of consenting, that she was incapacitated, that the defendant penetrated her vagina with his fingers. He put her hand on his penis and masturbated himself, and he fondled her breasts.
If that's true, why'd you need the 5 witnesses?
Well, Your Honor,
Great question.
This was our pre-trial assessment of the case.
He said, why did you need the 5 witnesses?
Exactly how our evidence was going to go in. And while we said we needed this evidence, we meant, in saying that, the evidence was very important to us because the victim didn't promptly report, because we knew from everything that the defense did first time around and leading up to the trial that they were going to relentlessly and ruthlessly attack her credibility. And in fact, they did. And we also knew that they were going to call Margot Jackson, who was their super witness.
That has nothing to do with harmless error. So we're going to hear from Mr. Fowler.
Yeah. It's like time to move on.
Good morning, Your Honor. Thank you for allowing us to split time. May it please the court, my name is Bob Fallon from the Montgomery County DA's office. I'll be addressing defendant's non-prosecution claim. He alleges that Bruce Castor in 2005 promised him transactional immunity.
Now, do you get more time?
Deciding to sit and answer
Will
questions
Jennifer get more time?
position.
That's the question.
The trial court, however,
Attorney Bundy.
hearings and hearing from the witnesses, found that there was no promise and that there was therefore nothing for defendant to rely upon when sitting for those depositions. Those findings and credibility determinations are supported by the record. That leaves this court, I'd submit, with no mixed questions of law or questions of law to answer. It is simply, the court does not have to reach the issues of promissory estoppel or any of the other legal or mixed questions that the defendant raises.
Counsel, could I ask you, counsel, pardon me, on that? Assuming for the sake of argument that you're right about there being no binding agreement, there would, under any circumstance, not be any argument about the prosecutorial exercise of discretion here. That is to say, as memorialized in Mr. Castor's press release, that a decision was made by the DA's office not to prosecute this defendant. Since we're the Supreme Court, this case obviously has implications well beyond this defendant. What is the lesson that emerges from your position in this case regarding the reliability of prosecutorial decisions? What is the implication for the thousands of promises made by prosecutors across the Commonwealth every day or every
We just talked about that in our open, right?
Plea deals, immunity agreements, non-prosecutorial cross agreements, agreements to cooperate with witnesses, etc., in return for something, etc. If your office's word is not its bond, and we validate your position here, what is the lesson that emerges from beyond this case for all cases going forward in Pennsylvania? Do you understand my question?
I do, Your Honor. And the fact is, prosecutors are bound by contracts that they enter into, or if they do make a statement that a defendant reasonably relies upon, then the defendant can seek some relief. The question here, it doesn't really reach that issue because the only thing the defendant can point to is a press release that says that the prosecutor is not going to press charges. That same press release leaves open the possibility that if the case will be reconsidered. In the press release, District Attorney Castor says, cautions all parties to this matter that he will reconsider this decision should the need arise. Not only that, but in 2015, he was interviewed by the Inquirer, and he told the Inquirer, I put in there, referring to the press release, that if any evidence surfaced that was admissible, then I would revisit the issue. And that is evidently what the DA is doing. So I think the lesson that this case would teach is that simply because a prosecutor announces he or she is not going to press charges in a case, without more, that does not give the defendant license to say, wow, that's transactional immunity. It's really prosecutor 101 that you do not close off cases, even if they go cold. You leave open the possibility that if new evidence is discovered, that you can then go back and live to fight another day in court. There is no reason for
You don't get a second bite of the apple.
Okay, I'm not going to press charges.
It's not how the law works.
Forever, no matter what turns up in the future. And no matter if a federal judge, as in this case, released a civil deposition and in an opinion said, this deposition reveals behavior that is perhaps criminal. Prosecutors should not and do not do that. They sometimes don't press charges in a case, but they never, in my experience, will just, for the sake of the civil case, say, we are never going to do that. And it's especially strange in this case because Castor ended this investigation while the investigation team was still strategizing on the next steps. And that's from Detective Richard Schaefer's testimony at trial. He said when he got the call that the case was closed, he and his team were still mapping out the next steps in the investigation. So
That's a call. Just one brief follow-up. Can I just have one brief follow-up on my question? A sitting DA made a decision, memorialized in a press release. You don't like that, you being the successor's office, that is. But why does that not bind you as the successor office?
John, I think because by its own terms, it's leaving open the possibility that it can be reconsidered. I mean, it's right in the press release, and there can be certainly, the court was talking about reasonable reliance if we get to that analysis. If we're just talking about strictly the press release, nobody should reasonably rely upon that for transactional immunity. That would be a horrible precedent to set. To say that when the actual document says the prosecutor may reconsider it, that defendant can take that press release and say, I am forever immune. And then a court is later going to enforce that. That is not fair. That is not fair to the Commonwealth, and it's unreasonable for defendants to expect that. If they are, yes.
All right, it's Justice Todd. Isn't it fair also to look at Mr. Cosby's reasonable reliance on the agreement he believed he had, based upon the fact that he went forward with the civil deposition and put himself out there for those questions and did not raise any objection at that time or invoke his right to remain silent? Isn't that indicia of reliance on what he believed to be an agreement?
Well, Your Honor, it is not. And I'd also just point out that the trial court did not believe that it was indicia of reliance, and that's really the key issue here. Whether the trial court had support in the record for its findings, and I'll explain why it's not indicia of reliance on this so-called promise from Castor. Defendant sat for a police interview with multiple detectives during the investigation, and he gave an exculpatory account of his interactions with Andrea Constant. He did not invoke his Fifth Amendment rights.
He did that
And his
willingly
lawyer,
because
Schmidt,
no charges
deemed
had been
rejected his
filed
testimony.
against him.
But Schmidt said that he had interviewed defendant before the detective interview, and he felt confident that the defendant would not incriminate himself. That's why Schmidt let him sit for the interview, because it served his client's interests. The defendant was able to get through that interview and end up giving an exculpatory account. Not only that, but he then, with Schmidt negotiating the deal in detail, in writing, in multiple stages, and
I hear you,
exchanging
man.
papers with the National Enquirer lawyers, negotiated for the defendant to sit down with the National Enquirer after the investigation and talk about Andrea and the whole incident. Again, he did not invoke his Fifth Amendment rights. The defense team, which was consisted of John Schmidt, Patrick O'Connor, and Walter Phillips. I mean, it's talking about an excellent defense team. They let him sit because it served their best interests. And so if he had invoked his Fifth Amendment rights at the civil deposition, he would have faced negative consequences. And in fact, the victim's civil attorneys, Troiani and Kivitz, they both testified, we wanted him to invoke. It would have been better for our case because, one, the jury would have only have heard from Andrea, and two, we would have had a favorable instruction that would have allowed the jury to infer that because the defendant invoked his Fifth Amendment rights, his testimony would be unfavorable. So, defendant sat for the civil depositions, tried to give an exculpatory account, and essentially did, although he slipped up and made statements that came back to haunt him. But he was trying to do exactly what he had done before. He sat for the interview with detectives, with the National Enquirer. He thought he could get away with it. His defense team thought he could get away with it. He was trying to avoid negative consequences of invoking the Fifth in this situation, and it backfired on him. That's what happened. There was no, and one important point, and I think Justice Doherty mentioned it earlier. The defendant, by his own allegations, believed he had transactional immunity for Castor, for Andrea Constant. That's it. No other victims. Yet at the deposition, he would not answer a lot of questions about Andrea. That's not consistent with someone unburdened by transactional immunity. He was compelled to do so by the federal judge. And yet, importantly, and this has never gone rebutted by the defense or even explained, is that defendant openly answered questions about other victims in other jurisdictions. Those victims would not have had any, he would have not had any immunity for those victims. Castor could not grant immunity for victims in California or New York or Las Vegas. So why explain that conduct? It's inexplainable if he sat because he had thought he had transactional immunity for Andrea Constant. So I don't think there was any actual reliance here, and that is in fact what the trial court found. And I want to be considerate of this court's time, but just in closing, I'd ask the court to, this court has established a deferential standard of review for credibility determinations and fact findings for a reason.
Combined total, Stacey, they gone for
The record
35,
does not
40 minutes.
capture everything that transpires in the courtroom. From the mannerisms, tone of voice, gestures, expressions, the change in demeanor as a cross-examination shifts from the beginning to the end. All these things aren't captured in the court record. And as someone who was there that day, both those days, I can safely say that this whole record does not capture everything that happened. But even despite that, if you read this record, there's ample support for the trial court's fact findings and credibility determinations, and that's really as far as this court, I would respectfully submit, has to go. This is an issue for the trial judge, and he properly resolved and denied this claim.
Thank you, Mr. Fallon. Unless there are any other questions, we'll conclude this argument.
Thank you, Your Honors.
Thank you, Your Honors.
Take a 5-minute recess and call the next case.
Well, there you have it. So understand that there's a decision is not expected right away. The average length of time for a decision is approximately 150 days. It could be sooner, it could take a little longer, but the average is 150 days for the Supreme Court to make a decision. But Andrew, we heard the arguments. Again, trying to be as objective as possible from our seat, from my seat, trying to be objective as possible. it seems like attorney Jennifer Bonjean really hit a home run today. We won't know for sure, but certainly now other people who wasn't in that courtroom got a chance to see just a glimpse of the disproportionate way in which things were stacked against Bill Cosby. Andrew, talk about what you saw.
Look, she did a phenomenal job, and my hats are off to Jennifer. This is what Mr. Cosby had been hoping for in his legal representation. He didn't get this in his last criminal trial. He didn't get this type of legal genius in an attorney who she nailed the points. She stayed on the facts. She stayed on course, and she wasn't all over the place. She answered the questions. Yeah. She gave a great presentation.
She did.
And I could definitely say that, I'm very well pleased. I hate, Stacey, so much has happened that, you try not to read things into what you see because, look, right. We've been dealing with this since 2014. We have been to countless hearings. We've been to countless jury selections. We've done the mock trials. Last week I participated in a moot argument with Jennifer and watched and observed her in action. And this was even better than the moot argument. And, although you want to say, hey, we won and this is going to be in our favor, you never know when you're doing behavior. Yep. You just never know. You don't know if you were just being thrown a curveball to throw you off tracks to make you feel that they're in Mr. Cosby's corner and they're going to rule in his favor and they're going to vacate his conviction. You want to believe those things based on what we saw and what your audience witnessed with their own eyes and people around the country witnessed. Mr. Cosby's conviction should be vacated. But because of politics, because of old skew scores, and when people are elected and selected to seats, you just never know. Yeah. You might be able to get to them within that time period of you're waiting for the 150 days. Yeah. So I'll just say that, look, we have our faith is overwhelming. And all we can do is just, ask for people prayers. And, this is no longer in our hands,
And Andrew, there's a couple of things I wanted to just go back to. He mentioned the Bruce Castor deal, and you and I talked about it briefly before it began. And one of the things that Bob Fallon for the Commonwealth laid out was a statement Bruce Castor gave to the Philadelphia Inquirer in 2015. Well, Bruce Castor, the trial judge in this case, refused to allow Bruce Castor to testify that, yes, indeed, we had a deal. And then additionally, Bruce Castor was very explicit in his direct statements, on the record statements to the black press. Yes, there was a deal. In fact, Bruce Castor said, and I quote, "What they're doing to Bill Cosby is un-American. It is anti-justice." That's Bruce Castor's quote to the black press of America. So just to follow up on that, and a big question from the justices to the Commonwealth: why did you need prior bad acts at all?
If you had a solid case against him, what one of the justices said, I think it was Justice Sayer. He said, okay, you said that you had proof that he digital penetrated her. You had proof that he drugged her. Why did you need 5 women to corroborate her story who was not there? They were not a part of that storyline. And as you saw that the prosecutor, she could not answer that question. She was all over the place. She had no answer for anything. But yet again, like I say, you want to read what you want to read into it, Stacey. But I thought it was a phenomenal day. I really do feel in my heart of hearts, and separating myself if I can, as a person representing Mr. Cosby, been representing him now for 12 years and the family. I can definitely say, this was a win. This was a win for us. Yeah. And I do feel that, vindication. This was vindication for Bill Cosby.
And Andrew, and speaking of vindication, over the last couple of months, you and I have spoken, obviously. There was some more misinformation. In fact, they released a purported mugshot of Bill Cosby looking disheveled, looking and not in the best light.
Right.
And then shortly after that, you released the latest photo of Bill Cosby looking like Bill Cosby.
Right.
Talk about that a little bit, if you will. Why did that happen?
Well, look, that happened with TMZ. They knew oral arguments was coming up. So the goal was right before Halloween, remind people that he's a monster. Show him looking disheveled, show him looking like a monster, a predator. And that was the image. First off, who contacts a network and tell me what news network or any network is monitoring mugshots of inmates? No one's doing that.
Well, particularly one that's already been in there for a couple of years.
Oh, wow. No one's interested in an updated mugshot. But that was to send a message to not only these judges, but to the public, because it's to sway public opinion. But what they did not know, October 12th, I had a virtual conference call with Mr. Cosby. Since I'm his only visitor, I'm on his list to do virtual conference calls. And we had the call. And what I said to him, not only did we have the call, the call was recorded, but I said, hey, let me take some pictures of you so that I can show Mrs. Cosby and your daughters, how well you look, how their father looked, that you're healthy. They're just not hearing it, because sometimes Mr. Cosby, has the tendency to care more about others than himself.
Mm-hmm.
And so what I did, he said, I said, well, hey, let me take a photo of you with the mask on, and now I'll count to 3 and you pull the mask down. And I sent those photos, confidential photos, to the family members only. And when I saw what TMZ had done, I held my photo, got in touch with you and others and said, hey, I have a photo of what he looks like today that was taken on October 12th. And that's how that came about. And people got to see Bill Cosby looking fresh, looking smooth, despite him being in a prison uniform. But he was smooth.
In a moment,
look healthy.
Yeah, in a moment, I want to get back to that and ask you how he's doing and talk about what you can tell us as to your most recent conversations with him. But I want to get to a question Mouse Fisher raises. He says, I don't understand when you say in a way that Bill Cosby is getting a better representation now. Are you saying the attorneys that Cosby had didn't do a proper job? Were they inexperienced or sold Bill Cosby out? I've always believed that Cosby was and is innocent. However, are you saying that with Cosby's wealth and prestige that he wouldn't have top-notch attorneys? What is it? Speak on the incompetence of his previous attorneys. Well, go ahead, Andrew.
Here's how I answer that question. People think, that when you have wealth and status that you get the best of the best. That's when you get the attorneys who really take advantage of you, because they know you want to get back to work. They know you want to hear only the good things, and they tell you what you want to hear. I'm not saying that our attorneys were horrible. I'll just say this, our attorneys were in a situation where it wasn't a friendly court. It wasn't a friendly environment. They put on a good show. They put on a good presentation. We filed a number of motions to suppress his deposition. We filed a number of motions to suppress the 404B witnesses. But when you have a judge who is on the side and teammates with the prosecution, you can't stop the corruption. You can't stop the destruction of exculpatory evidence. Look, we had a witness, Margot Jackson, who they tried to bar from being our witness. We had to file several motions before Judge O'Neill decided to let our star witness, who was a roommate of Andrea Constant, and heard her say that she had made up allegations against a wealthy known man that had raped her or drugged her. The charges was trumped up against us. They had a bigger team. They had more resources. They had
unlimited,
governmental dollars. So no matter how successful and wealthy you are, Tom Mesereau handed over the case to Kathleen Bliss. It was his case, but he handed it over. He felt the need to hand it over because of the Me Too era and how they had a big influence on the courts and public opinion. So that's where we stood. But don't always believe because you have wealth and you have status and success and means and resources that you're going to get the best representation. Those people normally get the poor representation.
Yeah, and Andrew, many people want to know, they want a better understanding of how involved Mr. Cosby was in his own defense.
Very involved. Every day, every hour, he never stopped calling. He would call these attorneys and get me to get these attorneys on the phone at 1 a.m. Look, I take a lot of responsibility for both trials because, my job was to vet the attorneys. My job was to seek out legal counsel. Not only, do I represent Bill Cosby, I oversee, everything. You see strategy. I come up with legal strategy with the attorneys, even though I'm not a lawyer. But that's what I do. And it's just, I always said law school is not to study law, it's to train it on the mind. And when you've been around been around the legal world as long as I have, your mind begins to, understand how the law works and how to come up with strategy. And, look, we had 2 trials going on, Stacey.
Yep.
A trial inside the courtroom and a trial on the courthouse steps. So, and we saw in 2017 that the courthouse steps trial is the one that got the hung jury. And unfortunately, it didn't happen that way in 2018 because there was a stacked deck. It wasn't just a trial now Andrea Constand and Bill Cosby, what we saw in 2017. We had a trial of Andrea Constand and 5 of her closest friends that were not ever her closest friends, but became her closest friends in a matter of months with the help of a corrupt district attorney, Kevin Steele.
Yeah, and how is Mr. Cosby? When was the last time you spoke with him?
We spoke a couple of days ago. He was resting yesterday. He did not speak to anyone on yesterday. He wanted to rest. He was anticipating this moment. He did not even call Mrs. Cosby. I had to call last night, reach out to the prison last night and got to talk to one of the lieutenants and the captains just to make sure he was doing well because she was concerned that she had not heard from him and she thought maybe that they were keeping him away from the phones or punishing him because of today. But they explained to me that he wanted to rest. He just didn't want to be bothered and he wanted to be focused and have a clear mind and just rest and think about today and think about, the sweetness of vindication. And we were talking, I'm expected to hear from him in the next 20 to 30 minutes.
And we earlier this year, as you well know, we had the privilege of having Mrs. Cosby on the program. How is she doing today as we speak? And what's her mindset for this morning?
Well, her mindset, she's in a great frame of mind. Matter of fact, Stacey, I was just texting her as oral arguments were going on. And I'll read just her response back to me. She said, she said, how's it going, Mr. Wyatt? Give me the play-by-play. And I said, Mrs. Cosby, Jennifer Bunjean is nailing the questions being thrown at her. Her answers are sound and very accurate. She looks good and her words are very convincing. She said, good. Finally, at last. Now we must move onward to vindication.
Well, and see, there you heard it here first. From Andrew Wyatt, from Mrs. Cosby through Andrew Wyatt. And that's what we try to do here at the Black Press and NNPA. Andrew, I'm pretty sure that you're anticipating your next conversation with Mr. Cosby. You sound upbeat right now, but you have also cautioned that, hey, politics can enter into the picture.
Right. Look, Stacey, in my role, I have to be upbeat. In my role, I have to look, like I said, both sides of the equation. And I'm just happy today. And my job today is to keep Cosby's legacy alive, is to keep the truth and facts out. That was not allowed. And unfortunately today they were allowed by this Pennsylvania State Supreme Court agreeing to review our appeal and to agree to review what was aired in Montgomery County court. But I feel good. Look, we all have been nervous, on edge. Look, we've been stuck in the house. We've been the country,
yeah.
The country has been shut down. So all you had time to do when we got word earlier this year that the Pennsylvania State Supreme Court was going to review his appeal, we sat around trying to figure out life, how to figure out how to stay healthy, and all of these types of things, how to keep our lives together. And we saw so much destruction and death around us. You know, a lot of people had one less seat at the dinner table this year for Thanksgiving. So, you know, we've gone through a lot as Americans. And you know, what I hope for this American citizen, Bill Cosby, is that, you know, he will be vindicated. His sentence will be vacated. And he will go on to provide his greatness and his humor yet again to a world that has changed now. No one ever saw this world change. But, you know, he's ready for this change. He's built for it. And we're all built for it. And we just thank you, Stacey, because I must admit, you know, you have not given us any special favors. You have been true to your word. You have not sensationalized anything to help benefit us. You just told the truth. And
well, it goes back, Andrew, you know,
yeah.
the black press, we're here to inform our community in a way in which the mainstream won't, right? And it goes back to what Mr. Cosby said some years ago in a conversation he and I had, you know, that you're well aware of. He said he wasn't looking for any special favors. He says, I only expect the black press to be fair.
Right.
He didn't want it. He didn't want us to slant anything. He says, what you see is what I want you to report. But isn't that what a journalist is supposed to do? And you mentioned earlier that you have a journalism background.
Yeah, well, it's what we're supposed to do. But now, you know, journalism is consumed. Now, I'm not knocking young people, but by so many young people, because, you know, these media entities want it for cheap now. And because of the world of social media and the news cycle changes about a millisecond, you know, you just you can't keep up with it. So now, in order to make a name for yourself, you just sensationalize everything. It's journalistic malpractice at its best. And the journalism that we once knew, Edward R. Murrow and those journalists from back in the day, that doesn't exist anymore. Stacey, you are a dying breed of journalists that exist today. We only have a handful. And what's so fortunate, you know, I did Roland Martin's show last night. He made sure he gave publicity to what we were going to be doing today live with NNPA. But, you know, those journalists, man, you guys are becoming extinct. And I just hope that the young people who have watched oral arguments and who have tuned in, that it creates some type of energy within them to say, you know what, I don't want to just tell a story. I want to tell a factual story, not a story to make a name for myself. Look, if you do it the right way, you will get the name. Yeah. I'm a true witness and testament to that. If you do it the right way, you would get the opportunity. We all would get the opportunity to go to the bat and try to, you know, hit that fastball and get a home run. And so far, so good. I feel that we got a home run today, and I feel that NNPA has given us plenty of home runs, and I just can't wait until the next interview you do it.
Well, Andrew, you know, I got a couple more for you before we let you go.
Right.
You know, you were there in Harrisburg when the first appeal, at the state level, the Commonwealth level, right?
Superior Court.
The Superior Court level, right? And what was the difference today in that argument there with the Superior Court? What did you see differently?
Look, we saw at that time, you know, the Superior Court, you had 3 justices. You had a black female, a white female, and a white male. We saw we were each, you know, given, you know, 15 minutes to perform. Our attorneys just didn't do their best. They were given an a la carte menu of things to discuss, and they picked marginal issues to discuss and to argue before the Superior Court. But I never saw us getting our win at the Superior Court. Look, we had many supporters that showed up from all the way from DC to New York, you name it. They were there, almost 30 supporters, even children showed up. But we never saw the win coming. We saw that court also had was heavily influenced by Montgomery County and the district attorney. So you hope for the best, Stacey, and that's why I say you know, you can't put all of your eggs in one basket. But we walked away that day last year not feeling good. I can definitely say that. And
Yeah.
I definitely say that our attorneys at the time, and I won't even give their names, didn't do a good job of representing Mr. Cosby. And that's why I say you could pay for good representation, but when it's time to perform, sometimes your money could just go down the drain. That's what.
And today, one of the justices made an amazing point. Can you talk about this point? He says that their decisions regarding this case have implications far beyond the case itself.
Well,
How important was that?
That was very important because if you go back to all of my press conferences and every interview that I've done, I've always said that this is bigger than Bill Cosby. This is not about Bill Cosby. Bill Cosby today, what he's going to be able to do today, if his sentence is vacated, or even if he's given a new trial and they throw out 404B because they know it's a murky law, he's going to be able to help all of the men and women who sit at some facility, some institutional prison institution in Pennsylvania. He's going to help them get a fair shake.
Yeah.
That's the beauty of this. That's the beauty of those people who are sitting in a cell today who don't have the resources or means of a Bill Cosby will now get an opportunity to possibly be free because of a corrupt and egregious, murky law called 404B.
Yeah, and finally, Andrew, you mentioned about what he will do, what he still has in mind to do. Are you telling us that when he is released, that we might see him do some stand-up or something in the entertainment world again?
The goal is when he's released is to go back on stage. He's written so much material in his mind, and now because he's blind, 100% blind due to glaucoma, he remembers things. Now he writes material that way. He calls in and dictates his material to myself and Debbie Meister, who works at the California office, and Mrs. Cosby. Look, he wants to revamp Fat Albert. We're all working on a possible book together with a wonderful writer who we will make public sooner than later out of San Antonio, Texas. But we're working with some wonderful people, and Mr. Cosby's goal is to be back on that stage, and to be back on that stage and talk about his experiences. Because think about it, all of his comedy it surrounds his life, Stacey,
right,
and surrounds his family life and what he's going through. Can you imagine what the comedy shows are going to be like? When he gets out of prison and he walks out on stage, or he's sitting in a chair with the curtains open and he's sitting in a prison uniform, a suit and tie, or a sweater. It's the new Bill Cosby, and so his greatness will always be around. He's the true GOAT. He's the true greatest of all time comedians. The comedians you see today, and not to knock them, but they will never be Bill Cosby. And he's the last of the greats that exist. And we just thank, all of his family, his friends, all of the people in the celebrity world who reach out and who can't be public because they're afraid of being attacked if they come out public. But we thank them for their support and standing behind us in these tumultuous times. But you know what? Bill Cosby was built for this. We were built for this, and we're going to get through this. And he's going to be even bigger and better when he's released and he's vindicated.
Well, Andrew Wyatt, the loyal, long-time spokesman and crisis manager from Purpose PR for Bill Cosby, we really appreciate you sitting in this morning and walking us through this very, very important Supreme Court hearing. Thanks so much, Andrew. Thanks, everybody, for watching. We're going to keep you up to date, and maybe we'll have Bill Cosby on this program sometime soon, too.
Well, we're looking forward to it, and thank you again, and thank you to Dr. Benjamin Chavis, your CEO, Norman, Rich, your producer, yourself, and all the people who work behind the scenes to make this happen. And within the next 30, 40 minutes, I should hear from Mr. Cosby. I will be sending out a statement that he would dictate to me to send out. I might be hearing from him any sooner by now, but thank you so much. This was a wonderful day, and it was a refreshing day for me. To relive it in this way, but relive it by seeing, a man who's 83 years old, his life being fought for by Attorney Jennifer Bongini. I just want to just send a thank you to her as well, because she did a magnificent job in representing Bill Cosby, one of the greatest entertainers of all time, and will always be one of those individuals 20, 30 years from now. So thank you so much to Black Press USA and NMPA.
Yep, absolutely. Well, and also, just so you'll know, if you want to make a statement, we can have you right back on this morning with that statement, Andrew, okay?
Definitely will. Thank you, Stacey.
All right, Andrew.
I'll probably be sending it out by email, but I'll definitely love to come back on if need to be.
Absolutely. Take care, Andrew. Everybody stay safe and stay well.
Thank you so much. Thank you.